Afternoon, sir, but I need to correct the impression. My clients are not accused persons yet. They are suspects.
Okay,
Yeah,
well.
because they've not even taken their statements.
Okay.
Yes,
Thanks for the correction. So, what is the latest state of your client now, as we do speak, following
They are still
yesterday's?
behind bars. They are still behind bars. My client, the male client, who is the Mr. Adu Boahen, has been incarcerated at the Yoko cells since Thursday. The wife, who followed through to visit the husband on Friday, was immediately arrested, and she's also behind bars. So Yoko and Attorney General have violated the 48-hour rule. There's a rules of a bail in which they want to keep the people on their own terms, and we believe that that is an aberration when it relates to the Constitution and the rule of law, and we challenge it.
So, as it stands now, your client is still in cells, but have there not been any plea bargain? Because yesterday, per the AG's address, he suggested that that should be the next step if indeed you want to cooperate, isn't it?
How can you talk of plea bargaining when you've not even listened to our clients, and you will not even give lawyers the space to share confidential engagements with them, so they will be able to know their legal rights in the matter? How can somebody be in captivity and he can think right concerning a matter? Is that what you call the reset rule of law that we are practicing? It's unfortunate.
Released a statement condemning the press briefing he had yesterday. You've described it as all manner of with adjectives over there. But what should you be? The next approach right now. For instance, your client is still in custody. He has not been heard. What's going to be the next step for him now?
We'll seek legal redress. Sure. You won't waste time at all. We'll seek legal redress. See, the finality of the justice delivery system is not with the Attorney General or Yoko. That is why the two of them cannot sentence an individual to jail. But if they want to practice law, they gather evidence clinically, not to sell, have big issues to the press and condemn people who the Constitution presumes innocent, that they are guilty. You see? So that the Attorney General is now a judge in his own right. This is a deviation of what we call constitutional law and rule. And this country should not encourage it.
Counsel.
You see? So what is the eventuality of the matter if you take your so-called sacrosanct evidence to court, and then you are not able to prove the matter beyond reasonable doubt, and you lose? You defame people for nothing. That is why in every serious criminal investigation is devoid of theatrics, propaganda, public relations gimmicks, and razzmatazz. You don't find any serious investigator trying to showcase the matter in the public domain. You don't find it. They do their work very well clinically. They give the suspect who might become an accused person when the docket is complete the opportunity to, give some semblance of a defense. And then when they've listened to both sides and they are persuaded that is a very good case, they go to court. But that does not even end there.
Right.
Whatever they have will be subjected to the test of the law. They call it proof beyond reasonable doubt. Right. You don't find it in the arena of the press.
Counsel, prior to the AG's briefing yesterday, did this come to your attention with any transaction and enterprises by your clients? Were you aware about this case and the allegations as well?
I'm not aware of any of these allegations at all. It is in the armpit of the Attorney General. That is why every sensible lawyer will have to see the client, meet the client, alone, not in the presence of local officials whom I want to record the confidential engagement. So you know and appreciate I mean, why has he been arrested? Did they tell him why? What are the matters they are investigating? Then you can then advise your client. And it's a constitutional requirement that when a man is arrested, he has a right to counsel of his choice. It's in the Constitution. The very document that the president, swore to uphold. So if today there is a constitutional, change of government, and the law should sit upside down, and let's feed frenzy to the general public and the world at large, and poison the atmosphere against people who the law presumes innocent, it's a pathetic state of affairs, and we shouldn't encourage it.
Counsel, I would want to ask you a final question, but you can sum all up, in two questions, but sum it up in one way for me. One has to do with the AG saying that based on the evidence he's gathered so far, and he also have, even if it's supposed to go to court, he's convinced that he's going to win this case. Also, how in the quest of you seeking justice to your client are you going to ensure that he gets out from the cells immediately?
In the first instance, AG is setting his own questions and marking them. You see, when lawyers call evidence, it is not what you feed the press. It is what is tested in court, under oath and under cross-examination. They call it adduction of evidence. Every lawyer of average intelligence knows that what is in your brief is nothing until it is tested. So what is the meaning of the evidence? Archibald calls what the Attorney General is having and the theory of the prosecution. So there's no evidence at all. He shouldn't be singing his own hallelujah chorus and be glad. He's even talking about plea bargaining when he's not heard anything from the suspect. Well, we as lawyers who seek legal redress and ensure that the respite that our clients need by way of a bail will test it in the court, because I don't think they can keep them permanently. They are not guilty yet. They are innocent until proven guilty, and it's the law sitting upside down when the innocent is being, incarcerated by the captors. It is wrong in law, and we shouldn't permit it.
Right, but finally, once again, what's the bill condition like? How much is involved here?
Well, we're talking about 120 million Ghana cedis relating to Mr. Adu Boahen, and 80 million Ghana cedis relating to Angela, the wife, and this is to be justified, which simply means that then go and bring this property. When you can bring this property, maybe we don't like this property, you see. And it is very, very sad when the one who is joined this against you is determining your freedom. So what if Yoko says we are not satisfied with what you've shown us? Then they remain there permanent. Is justice with Yoko or is it with the court? You go for justice, which is with the court, not our captors.
But in the event of seeking for justice and also seeking to meet the bill conditions, are you able to meet the terms and conditions involved?
Of course, because the court says that the bill conditions should be reasonable. That is the operative word, in the law. Reasonable. It shouldn't be onerous. So you use the bill conditions as a weapon over the head of a suspect. That is unfair. That is a very cruel and subtle manner to detain him. If you make the bill conditions burdensome and it can't be satisfied, that's a subtle way of breaking the 48-hour rule, and the court will see through that. Now you are using the power of your office to detain a Ghanaian unduly, unlawfully, and capriciously.
Indeed. Counsel, we're grateful this afternoon you could speak with us.
I'm grateful to you as well for giving me this space.